Hi, my name is Graham Hayward. I'm Managing Director of Housing Hand. Housing Hand are the leading provider of guarantees to the UK rental market. The conversation today is around the Renters' Rights Act, and that's so relevant for Housing Hand because we help manage the risk of those changes in the rental market. I'm delighted today to be joined by Ryan Heaven.
Hi, I'm Ryan. I'm a consultant solicitor at Woodstock Legal Services, and I deal with all things letting, so hopefully I'm going to be able to answer some questions today. It will make things easier if I start with some definitions, because we're going to be using a few terms over and over again, and it makes sense not to constantly interrupt and re-explain ourselves throughout. So when we talk about HMOs, we are talking about non-licensable HMOs. We're talking about the broad definition of HMOs. A property may require a HMO license if it's a HMO, but broadly speaking, you do not actually need a license for all HMOs. This is important in context of ground 4A for assured tenancies. PBSA. Now, purpose-built student accommodation are expected to be exempt from many of the rules of the Renters' Rights Bill. We do not yet know how they're going to be exempt, but it's likely going to be an amendment to a schedule of the Housing Act, which currently only applies to university accommodation. So PBSA will be exempt from most of the rules, but there are certain ways in which they will still be affected by things that are in the Renters' Rights Bill. So when we're talking about PBSA and things apply to them, we'll be specifically saying that. Otherwise, by default, PBSA do not get affected by these changes, other than to say that they no longer have assured tenancies.
So under the definitions of types of tenancies and PBSAs against HMOs, are PBSAs still allowed to take rent in advance?
So whilst the Tenant Fees Act does apply to PBSA, so they can't take prohibitive payments, that sort of thing. The bit about advance rent, the mechanism for it only applies to assured tenancies, and PBSA by definition are not assured tenancies, so they can take advance rent.
It's clear that PBSAs can take rent in advance. Now for HMOs though, that will be prohibited. However, I understand that there's quite a nuance between when a tenancy started and what happens afterwards.
The introduction of the ban on rent in advance, I think, was quite hasty and muddled, and I think it's caused a lot of confusion in the market. So it might help if I break this down to kind of three clear stages. Step one, before the tenancy agreement is signed, you cannot take rent. Between the tenancy agreement being signed and the tenancy starting, you can take rent 1 month. That's the absolute maximum. After the tenancy agreement starts, if the tenant wants to pay, then you can take that money, but you cannot encourage it, invite it. It can't be a term in your contract. If it is a term in your contract, it's essentially unenforceable. So there's lots of restrictions on being able to do it. But if a tenant of their own volition decides, I want to pay you this money up front, you can accept it, essentially putting their rental account in credit.
There's no obligation that can be enforced in that regard, but for students, for instance, who have termly grants and things like that, that might be a practical approach. The challenge is it's not going to be legally enforceable.
Yeah, indeed. So for students in particular, they're going to be getting their money in instalments, big chunks of money. So it may well be that they go into arrears for a month or two and then bring it right back up when their grant comes in. They can pay it all in bulk. So you're going to get quite uneven, jaggedy cash flows. But really, that's not any different to what you get currently, is it?
No.
It's just that your Excel spreadsheet is telling you that they're in arrears. But in reality, in 2024, they were doing this exact same model of just paying every 3 months or so. So I think so long as your accountant can handle the fact that there might be some red numbers where previously there were some green numbers, cash flow is the same, it makes no odds at all. So yes, you can do that, again, once the tenancy has started.
Yeah, and it's that part about not being able to take rent in advance will probably make the red numbers there rather than the green numbers.
Yeah, indeed. You may well be starting in the red, even if they can subsequently bring it back up.
Obviously, PBSAs can take their rent in advance, but for HMOs, they can't take that rent in advance. And so they would actually start the tenancy in those terms in the red, and then they would move back into the green once they made a subsequent payments, if that was what they wanted to do.
Yeah, indeed. So you may well be starting in the red, so to speak, where previously you'd be taking 3 months, 12 months up front. Currently, well, in the future, you're only going to be able to do 1 month. But as long as they bring that up to date, as they surely will, in line with their student loan payments, then there shouldn't be an issue.
And probably even more reason why you want a guarantor to underwrite that.
There are other fees that you can take before the start of a tenancy though. So you can take your 5-week deposit. You can also take a holding fee. You do need to be careful with the holding fee. I know some people are concerned about this 15-day period where you have to return the holding fee if you haven't entered into the contract. Now that 15-day period is negotiable. It can be extended with the parties' consent. So I think that really has to be part of your process. If you're going to be waiting for, say, the 1st of March, this kind of 6-month, the start of this 6-month period before tenancies are due to start, then you really need to be including, when you're taking a holding fee, some provision to say the parties agree to extend it up to X number of days so that you can enter the agreement 1st of March and it also not breach the holding fee rules. Now, just as a reminder, deposit caps, 5 weeks rent, holding fee cap, 1 week rent. If you're taking more than those fees, that's a prohibited payment. That's nothing new here. This isn't to have renters' rights. This is just a gentle reminder for what the Tenant Fees Act says. So
just in terms of implementation, you can have currently clauses in current contracts. You're writing business as normal, obviously until the bill comes in. But any clauses that such as annual increases in rent, how is that affected when the Act comes in?
Well, you are going to have clauses in contracts that have already been signed to start in the next academic year. That's just reality. There are going to be people out there with those clauses in them. They become null and void, essentially. It's this classic issue of statute, so primary legislation mandated by Parliament, overriding contractual law, contracting between two people. So if you want to put a rent increase clause in a contract, Parliament says you can't do that.
So currently, people are writing contracts, the market's writing contract for tenancies. When the Act comes in, things like rent increases or other clauses, how are they affected under the new Act?
Yeah, you're right. People are currently handing out things called assured short hold tenancies. And when they come into force in September for students, they will no longer be assured short hold tenancies. It's totally possible that the law will have changed between agreeing the agreement and they're actually coming into force. So some clauses in there, like for example, fixed terms, rent increase clauses, are simply not going to be enforceable. The way that law operates is that statute overrides contract. So if the Parliament has passed some legislation to say you cannot do X, Y, Z, if you want to create a contract which has X, Y, Z in it, then Parliament says that's not allowed. So you don't need to do anything, you don't need to resend the contracts, you don't need to amend anything. It's simply by operation of law, those clauses, fixed terms, rent increases, will simply cease to exist. It's as though they weren't there. Now, student landlords have the option of trying to create an artificial fixed term. So what they can do is they can serve Ground 4A. Ground 4A can expire between June and September of the subsequent year. So they can try and bookend, create a bit of a fixed term, even if it's only in the tenant's minds. Now, practically, that doesn't actually create a fixed term. The tenants still need to leave in accordance with that to end the tenancy. If they don't end the tenancy, they overstay the notice. The landlord needs to consider what they're going to do about that. Do they let them stay for a little bit if they want a little bit longer? Do they go to court to escalate it to possession? There's lots of uncertainties about what the process is going to be. But if a landlord wants to create as much certainty as they possibly can, they really ought to be, as just a standard course, serve these notices.